I have a degree in communications from Texas Christian University. During college, I wired computer networks, and I trained faculty members how to use software. I also worked as a DJ on the college radio station, which was a lot of fun. And my first job out of college was as a software trainer. I traveled the country working with attorneys and paralegals, helping to organize their transcripts and e-discovery. And this was way before they ever called it e-discovery. That work quickly turned into helping trial attorneys with their presentation technology and graphics in the courtroom. The first case I worked on was the state of Texas versus Big Tobacco in 1997 in Texarkana. Trial presentation was still very new back then. Video depositions were on beta and VHS tapes, and since laptops weren't powerful enough yet, we used these massive, we called them lunchbox computers that we had to lug around. All of the synchronization of video depositions to the court reporter's transcript was done in real time by hitting the space bar on each and every line of the transcript. Very painful. I worked with several attorneys who were tasked with reviewing fact and expert witness testimony. I got to watch every single deposition in that case. And like a lot of cases, it settled the day before opening statements. I learned a lot about trial work and the industry. I would have to say Conwood versus US Tobacco in 2000 in Paducah, Kentucky. It was an antitrust case related to exclusive vending agreements for moist snuff chewing tobacco. That case taught me the true meaning of multimedia in the courtroom and really what visual storytelling is. All of the video depositions were synchronized. We had all the normal things, document scans, PowerPoints, and even blow-ups. But the best visual we created wasn't on a computer screen. We actually built a storefront to simulate what the jury would see when they walked into a convenience store. Our side won the case, and it's the largest antitrust verdict ever collected. Well, most people say the variety of cases, and I agree. While we occasionally work on bet the company intellectual property cases with billions at stake, we also get to work on simple slip and fall premise liability cases. The cases are always different, but the goals are always the same. What's our story? What are the case themes? And how do we tell the story to the jury or the judge using strong visuals and the best presentation technology? Whether it's a bench trial, 12 jurors, or 3 arbitrators, the trial graphics we create have to tell a story. Figuring out what the story is and how to tell it, that's the fun part. The obvious one is technology. Everything's faster, smaller, and less expensive. Who knew you'd be able to synchronize a deposition in a few minutes or download a 2 gig video file in 5 minutes? Today's software tools allow us to create visuals that are more subtle and refined, which would have been difficult in the past. Our technology and graphic consultants have interesting backgrounds outside of their primary skill set as well. Degrees in German, Spanish, computer science, and cartooning, just to name a few. You can expect someone who is well-versed at understanding complicated cases with 2 decades of experience. I'm also used to last-minute requests and long hours. When I'm at home, I enjoy anything that doesn't require a computer or a phone. I like cycling, weightlifting, carpentry, traveling, and I love spending time with my wife and my kids.